That concludes the discussion on the bill. The Honorable Minister to reply.
Sir, I first of all would like to thank the distinguished members of this House who have unanimously, I think, without exception, supported this bill. And I have to say that when I rose to initiate the debate or continue with the debate, I tried to keep politics out of it because I thought this was an issue which impacts 120 crore people of this country. And if we were to bring politics into it, it would derail the debate. There were a couple of discordant notes about Sharmnak defeat and things like that. And I will not rise to the bait because I think that we still must rise above these perhaps remarks that could have been avoided. Defeat and victory are part of politics. We have been defeated several times before. We shall be defeated again. You have been defeated several times before. You will be victorious or you may be defeated. That only time will tell. But no defeat is Sharmnak. It is the way you look at it that is Sharmnak. Having said that, sir, I will just refer to the points made by the distinguished member, leader of the opposition in this House. And he made three distinct points. First of all, he said that he was a little concerned about the fact that at the time of initiating an investigation, the delinquent officer is being given a right to represent. Well, the background to this, and I can share that with him, though I'm bringing the amendment to ensure that at the time of raid, seizure, and search, there is no opportunity given to the officer. But the thought behind it was that under the present system of things, a Group A and a Group B officer has the protection of Section 6A of the Delhi Special Police Establishment Act, even at the time of starting of investigation. For the reason is that most of these officers are Joint Secretary and above. And if a process is started against them and there's absolutely no explanation sought from them, it would do some injustice to them. So it is with that intent in mind. It is not an opportunity to hear that we were giving them. It's that in the event a prosecution is to be started and so there are certain materials and documents available, they can be asked for an explanation and that's all that is given. So having given an explanation to them, we are also making sure that if the department or the investigating agency wishes to seize and search, there should be no impediment in the way. And it's in that context that particular provision was incorporated, and I'm sure the distinguished members of the House will understand the intent behind it. That's point number one. Point number two that was mentioned was that there is a Section 63 now in the Act where we hope now that all state governments will take note of the fact that we've passed a very strong, a very independent Lokpal bill to deal with the menace of corruption. And we hope that every state government will take this as a model bill and then in the course of the next 1 year draft a legislation consistent with this particular one. We of course cannot give a direction because legislatures in states have plenary powers. We cannot interfere with those processes. And the legislature ultimately will have to decide on its own as to what kind of bill should be passed. But I must say, and I want to place it on record, that while we debate these issues in this House and political parties are involved, the real test of every national party or state party, if they really believe in dealing with corruption, is to how quickly they pass this bill in the state in which they are in power. If they don't do so, then the people of this country will realize that you spoke with one voice in this House and you are double speaking in the place in which you are in power. And I am sure that 46 years will not pass when state governments will adopt this particular bill in the respective by the respective legislatures in the next 365 days. But yes, it is be inconsistent with the principle of federalism for us to give any direction to any state government. The third point that the distinguished leader of the opposition made was in respect of the reservation for religious minorities. I would like to draw the attention, and he is a very dear colleague of mine, to Article 16(4) of the Constitution, which is the only article which provides reservation in the context of employment. And if you really could carefully look at the words of Article 16, you will find 16(4) is the provision that provides reservation, and I'll just read out. You're familiar with it, but there may be distinguished members who are not. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the service under the government, in the service under the state. The policy of reservation applies when you are serving under the state. The policy of reservation does not apply when you're not serving under the state. This is a unique piece of legislation. This is not service under the state. In fact, we are doing just the opposite. We're trying to put in place individuals who are Lokpals, who are not under the service of the state, who are independent in the exercise of their power, and therefore there's a big distinction between serving under the state and appointing a representative group of people which represents the democratic fabric of this country in the Lokpal to ensure that no particular community is dealt with in an unjust manner. And we've seen that happening. We've seen that happening in various parts of the country. So that's my response to the distinguished leader of the opposition. There are several other issues that have been raised. Sitaramji, in fact, raised the issue of supply and demand, and he mentioned his mentor in that context, who always talked about supply and demand in the classroom. I can assure you that we are dealing with the issue of supply as well. We are dealing with the issue of supply in the Prevention of Corruption Act. That amendment is already, as you are aware, that amendment bill is already in place. It is the Prevention of Corruption Amendment Bill 2013. It is pending in the Lok Sabha. And that bill actually deals with the supply side corruption. So I want to inform my distinguished friends that yes, we are cognizant of that fact. We're not bringing it into the Lokpal, but we are certainly bringing it under the Prevention of Corruption Act so that supply side corruption can also be dealt with effectively. Shekenduji talked about some clauses in the bill and said, why should we have judges who are appointed in the Lokpal, 50% of them will be judges. Well, we do it because we believe that when you're dealing with complex legal issues, complex financial issues, complex other kinds of issues, we need some legal training. And what better training than a person who has been a judge of the Supreme Court or Chief Justice of a High Court or the Chief Justice of the Supreme Court of India. He also mentioned about the fact that why should you not have MPs in the Lokpal or members of the Legislative Assembly in the Lokpal? And the reason is simple. They are subject to investigation.
I only say, why you have brought this provision debarring the members of Parliament? There is no need because you have already said that these people will be the chairperson or members.
That's what I said, that why are we debarring? For the simple reason there's a conflict of interest there. Because the purpose of this law is to deal with members of the Legislative Assembly and members of Parliament. And if they are the ones who are going to be represented in the Lokpal, there's going to be a problem, there's going to be a conflict of interest. If they belong to a political party or a particular political party, they will be biased in the processes within the Lokpal itself. So we don't want that conflict to happen. Shivnant Tiwariji, I think you made a very, very important point, and the point I think has been reverberating in this House. Many members have, in fact, spoke about it. You can have a Lokpal, and legislation is all work in progress, because legislation essentially is a response to what people want. It's the surge of opinion within society that sensitizes the legislature to actually come up with the legislation to deal with society. But the response of people keeps on changing because the needs of people keep on changing. So naturally, therefore, legislation is always work in progress. And if you want to deal with corruption, law alone will not ensure elimination of corruption. I am of the firm belief of that by itself, laws are will help deal with those who are corrupt. But laws will not deal with the impetus of human beings to be corrupt. It will deter human beings, perhaps, if the law is effectively administered, but it's the inequality within society, जो गरीब और अमीर आदमी में जो अंतर है, जो एक लिबरलाइजेशन की रेजिम के द्वारा जो आज काम हो रहे हैं, वो जब डिवाइड को हम खत्म नहीं करेंगे, तो तब तक हम पूरी तरह से इसकी लड़ाई नहीं लड़ पाएंगे। तो ये बहुत जरूरी बात है। ये जो आर्थिक अंतर आया है, उसमें हमें और जोर लगाना पड़ेगा, और हमें सरकार कोशिश कर रही है कि आम आदमी के लिए हम काम करें। मैत्रेयन जी ने भी बहुत सी बातें कही। He talked about the December 2011. The fact of the matter is that this is really what democracy is all about. That despite the fact that we have differences of opinion, we can get together. We can get together, and we can ultimately arrive at a consensus. There is no need to score brownie points that I was responsible for the consensus or somebody else was responsible. It is the collective will of this House which ultimately has delivered. And we need to congratulate the collective will of this House, in which the leader of the opposition is a part, Satyapat Chaturvedi is a part, and every member of this House who was represented in the committee is a part, and I congratulate all of them. All the other distinguished members, Ramalingam ji, Parida ji, Trivedi Saab, everybody, Ashok Ganguly Saab, Chandrasekhar Saab, Ravi Shankar Prasad ji, all ultimately supported the bill, and they mentioned that we should bring some of the other legislations. I want to just mention that this government, in fact, is the one that has brought these legislations to the House, either in the Lok Sabha or in the Rajya Sabha. The Prevention of Corruption Amendment Bill 2013, the Rights of Citizens to Time-Bound Delivery of Goods and Services and Redressal of Their Grievances Bill 2011, the Public Procurement Bill 2012, Bill to address foreign bribery as required under Article 16 of UNCAC. These are all pending in the Lok Sabha. The Lokpal and the Judicial Standards and Accountability Bill, the Whistleblowers Protection Bill 2011 is pending in the Rajya Sabha. And if the House, both Lok Sabha and Rajya Sabha, were actually functioning on a daily basis, hopefully these bills would have been passed. But unfortunately, we hadn't had the time for one reason or another. And I don't blame anybody, because this is not the time to blame. Let us all try and work extra hours to bring these bills to the House and to have them passed, so that we don't have to blame each other as to why they did not bring it and why they did not pass it. It is with this intent that I have not responded to some of the discordant notes, because I don't want to. Prime Minister. As far as the Prime Minister is concerned, this is now the consensus by and large of the House that the Prime Minister should be included. No, we respect individual opinions. We respect opinions of individual members. But that's the consensus of the House. The UPA stands by that consensus. I'm sure the BJP or the NDA also stands by this consensus, and I think the left parties are also agreeable to it. Yes, there are points of view which we respect. But
Please, let the Honourable Minister continue. Please,
with these words, sir, I commend the bill to this House.
Please.